So, what is commercial awareness? I think that I don't know about you, but I didn't really know what commercial awareness was when I started my applications. I thought it was just if you read the FT, then you were commercially aware. And that wasn't really helpful at all for me, at least just reading the FT and not doing anything else with it.
Yeah, for sure. I mean, I think it's definitely important to sort of develop commercial mindset as an aspiring solicitor. And this is sort of the very popular commercial awareness buzzword, and often quite confusing to understand. But I thought, the terms can broadly be translated into sort of recognizing why businesses behave as they do. And so, yeah, we thought it'd be helpful to break down commercial awareness into three parts. The first part is to remember that firms exist to make money. So understanding how firms operate and how businesses operate. So firstly, firms stay profitable by adding value to their clients. So the more value a law firm can add to their client, or the problems the firm can solve for the client, the better the firm will perform as a business. Therefore, they want to know how you can add value to their business to help them with that process. What did you think, Daniel?
Yeah, I completely agree. I think that, adding value really comes from sort of firms being able to deliver really good service efficiently to clients, because then that means that their sort of overheads are reduced. And so sometimes they can pass that cost benefit on to clients. And so clients really love that. So one of the things that we'll talk about later in adding, we actually have a slide on how to add value, how firms add value to clients. And things like, AI to reduce sort of hours spent on document review and things like that are ways that firms can add value, because it means that they don't have to spend as many hours. And so if they're using a billable hours model, then that means that cost reduction is subsequently passed on to the clients. So, but yeah, ultimately, I think a lot of people forget that law firms are businesses as well. It's not just their clients who are businesses. So they're always looking to sort of be innovative and offer the best possible service and remain competitive.
And I think once you understand, how law firms operate as businesses and sort of their commercial objectives, it's easy to understand what a law firm wants out of you. So you want to demonstrate to firms that you have the ability to understand a commercial problem and act in their best interests as well, and sort of bring in new business and things like these. So crucial to understanding how you can sort of add value to a firm is also understanding how a firm can add value to its clients and its position in the legal market. So this will typically depend on sort of various sort of commercial challenges and opportunities facing the client industries, which sort of brings us to the second component, which is sort of understanding the wider impacts of events on law firms and client industries. So as Danielle was saying, sort of reading the news and sort of keeping your finger on the pulse of commercial developments is certainly an important part of being commercially aware. But it's also important to sort of link that back to the potential impacts of these commercial events and current affairs on businesses from different industries and sectors. So you might want to ask sort of how industry players and clients might respond to these events and why they might require law firms as a result of it. So, for example, a law firm practice group could service client demands in response to a particular commercial event. You have to ask these kinds of questions. So different law firms service clients in different ways and rely on sort of different practice areas as their main sources of revenue. So developing a general understanding of what each practice areas do will really enable you to understand how law firms add value as businesses, and particularly how they add value to their specific clients in these sectors. And these sectors can include sort of banking and finance, M&A, construction, projects, litigation, things like these. So having understood how law firms might service clients in these ways in their capacities of their practice areas, the next step is asking why a client might be pursuing a particular venture requiring said legal service, and indeed how that will add value to the client's long-term vision and business. So, for example, if your client is a startup, they might be looking to raise finance for the first time and will you seek a law firm's help in terms of their finance department to help them through that. Or if it's sort of an established conglomerate, they might be looking to acquire a new branch to expand their client base, grow business, or diversify risk, for example, if they're an investment company. Or are they merging with a technology company to sort of help create new synergies or help create new efficiencies? Basically, how might a law firm's practice areas be able to assist with a client's goal? I was speaking for far too long.
Absolutely. I completely agree with that. I think that understanding sort of where law firms fit in with business ventures is so important. And also, as you mentioned, you've got to think sectorally. You've got to think in terms of the sector. So when you're, reading about stuff or looking into big events, think what kind of sectors is this going to impact? And then from the sectors, you can look at the practice areas, because obviously practice areas work across sectors. So it might not just be one department that this potentially big issue is going to impact. It could be across a wide range. I always think it's good to think in terms of looking at sectors, just because you know that if it impacts a sector, it's going to impact all of those businesses within that sector, rather than it being like a small news story. I'd always recommend going for sort of the bigger news stories that do have that sector impact.
Yeah, no, completely. And then I guess that sort of nicely links us to sort of the third component, which is reading the news and staying up to date, which is what everyone thinks of when they think of commercial awareness. So there is definitely an element of sort of understanding the Financial Times, reading it regularly, and The Economist. But if you're anything like me, I had no idea what it meant. Half the words they were using when I was first given a paper, and it was pretty terrifying. So I found sort of a good way to go about that was sort of invest in sort of a basic sort of foundation of sort of finance concepts and knowledge, commercial concepts and knowledge. So sort of reading books, Investopedia is a great place to start. And then once you build up that foundation, then it's almost like you're learning a new language. And then what the Financial Times is trying to tell you makes so much more sense. I will say, I'm a law student, but I'm not a big reader. Like, I don't even like reading. So I downloaded this Financial Times podcast app, and The Economist has a great one as well. And so on my commute, I would just sort of play this, podcast, about a 10-minute update every morning. And it would just sort of give you a rundown of what's happening, what it means for businesses. And then you can go through the step-by-step structure, this 3-step structure in your head. How is this going to impact clients, their industries more broadly? And what might law firms be able to do to add value? And then what might a law firm do to maximize their own value as a business as a result of that? So, what did you have anything to add, Danielle?
I'm the same. I respond much better sort of podcasts and videos and things like that, and that's why when I was learning about derivatives and stuff like that, I'd use YouTube channels to sort of explain things a lot more concisely. And it also, I don't know, I feel like I respond and absorb a lot better, whereas if I read, I tend to forget it quite quickly, because in podcasts and stuff, they tend to emphasize words, and it's just in the way of the language, and it makes it a lot more engaging. But obviously other people do like reading, and I did read, even though I wasn't the biggest fan of it. But yeah, I think that the biggest mistake that I was making was delving straight into the FT and not knowing what was going on. So like in second year, when I realized I wanted to be a commercial solicitor, I was like, okay, need to read the FT. Everybody's saying read the FT. But I was reading, I think it was like a private equity article, and I had no idea what a hedge fund manager was. I had absolutely no idea what was going on, but I was like, okay, I've read it, so I'm commercially aware, right? No, I wasn't, because I didn't understand it. And so, understanding how business operates, understanding the wider impact of events is super, super crucial to actually getting the most out of reading the FT. But equally, if you found the FT difficult at first, like I did, don't feel like you have to delve straight into it. I personally found easing my way into the FT by first using BBC Business and The Economist was a lot more accessible, because the FT assumes that you know, whereas I feel like BBC Business and The Economist kind of explain things to you. So I personally found that a good way to sort of ease into the FT. And then the FT suddenly made sense, a year later after I'd done all of this. But yeah, just reading the FT alone without understanding those first two things won't be the best idea. It won't be particularly valuable for you.
Yeah, for sure. And we've got like a long list of like resources that we use that we found helpful to sort of make those entry level steps into sort of improving your commercial awareness before you just jump into the deep end. So yeah, we'll come to that later, but hopefully that will be useful.
Yeah. Okay, so as Joe's already mentioned, it's so crucial to understand practice areas, but for interviews, we sort of pinpointed 3 that were probably the most useful to really know about. For me, I also looked into real estate just because I have an interest in real estate. But if you have if you're sort of new and you don't really have a particular a strong interest yet because you've not had that exposure, or if you do find one of these really interesting, then I'd really recommend going in and knowing these three in addition to the other ones that you may like. I feel like these are the main sort of focuses of city law firms. I've noticed that, Slaughters is really sort of heavy on corporate and finance. If you look at Herbert Smith Freehills, they're really heavy on corporate and dispute resolution. If you look at most US firms, it's corporate and finance and arbitration element of dispute resolution. So I feel like it's always a winner to know about these three in at least some fundamental capacity.
Yeah, and even if the firm you're applying to has a particular niche that it likes, so for example, you're applying to BCLP, which is famed for real estate, or firm I'm at, Vincent & Elkins, a sort of very sort of specialist energy niche. It's a great idea to sort of develop that sort of sectorial knowledge, but it's all going to link back to corporate finance and dispute resolution at the end of the day. These are sort of the three fundamental practice areas you need to know that sort of link and overlap with everything. So yeah, these are a good few starting blocks for the process.
Yeah, absolutely. I mean, if you look at real estate, for example, there's always a finance element there when they're looking to finance the real estate project. And if perhaps something goes wrong, then within that real estate project, then you'll need the disputes team, and also you may need the corporate/commercial team, because a lot of firms have corporate and commercial, to come in and do the contracts. So there's these three really do sort of span across most practice areas. And again, look at competition law. Often involves a lot of concentrations, so mergers and acquisitions. Obviously corporate would also get involved there, and how to finance the acquisition, finance would get involved there. So yeah, I think these are the best sort of to start off your learning with.
Yeah, so should we move on to private equity?
Yes, so you are far more knowledgeable on this than I am.
Well, so private equity is sort of like the bread and butter of a lot of US firms. A lot of US firms sort of specialize in this. They've basically leveraged all of their clients from America and New York, sort of the big boys, as it were, and sort of brought them over to their London office and are manipulating these relationships to really excel in the market. So you'll find a lot of US firms have a stronghold on this, and that basically a lot of firms is like 90% of what they do, or more or less, maybe not that much. But yeah, so private equity firms, what is private equity firms? So private equity firms operate funds that pool investments to buy assets with the intention of selling them off at a profit approximately between 5 to 7 years later, maybe longer, maybe shorter, depending on the firm. And the firms themselves have investors. They need to get their capital from somewhere. And these often and typically include institutional investors, such as pension funds, insurance funds, hedge funds, mutual funds, sort of sector specialist funds like real estate investment trusts, things like this. And occasionally very, very wealthy individuals, but typically private equity firms have sort of investor limits as to who can invest in them. So you'd have to be extremely wealthy. So that's quite rare, but it's worth including. And so these funds hold a lot of capital themselves. So these institutional funds hold a lot of capital themselves from their own investors. So for example, a pension fund will have sort of pension plan participants that are funding their business. Insurance funds will have insurance policy holders that are channeling their money towards them. So that's where they get their money from. And you want to make sure, and they want to make sure that the value of their stored capital is maximized. So they invest it into the private equity funds and expect to have a return on capital 5 to 7 years later. So effectively, they're locking up their money into this private equity firm, committing it to them. They can't get it out until this 7 year or whatever, however long it is, period is over. And then hopefully they maximize their investment and increase it. Whereas if they were to just, for example, keep it in the bank, it would devalue relative to the rest of capital that's being flown about as a result of things like inflation. If you look at the current economic climate with central bank interest rates very low, it's a much better idea to sort of borrow and invest in things as opposed to sort of let it sit in your bank account because the interest rates are so low. Daniel, did you want to talk about hedge funds briefly?
Yeah, so this was what I did actually learn a bit about when I was on the Bank of America scheme with aspiring solicitors. So yeah, as I've said, a hedge fund is basically an investment fund where they just pool all of their different funds from different investors, and their goal there is to like purchase monies to companies or different other assets in order to make a return, and quite a lot they make a big return. So one of the interesting things about hedge funds is how clever they are. So last year was Elliott Management purchased AC Milan. They acquired AC Milan because of a default. So what they had done is they had lent the previous owner the funds to purchase AC Milan and given him like an 11% interest rate. So if you look at that, that quite clearly says either, you know, we believe that he is not going to have the funds to pay it back, so then we can end up acquiring it for a fraction of the price. Or if he does manage to pay it back, we've got 11%, which is really, really high interest rate, especially when AC Milan cost a few billion. So I personally think they're really interesting in how they operate. And you know, there's been such a proliferation of people having to go to hedge funds because obviously since the 2008 financial crisis, a lot of banks have sort of been reluctant to lend for a lot of things that are deemed quite risky, and obviously things like that are risky. So then people or companies end up going to hedge funds to get a loan, and they obviously pay quite a lot of interest. But I just think the whole thing is quite clever. And one of the key terms I was told to learn how to define was fund manager, because when I first heard it, I thought it was like a person who worked at the hedge fund, but it's not. It's a company who decides where to invest. So that's one of those key terms that you should sort of know for any sort of case studies or articles that you may get. And obviously, as we've said, US firms are traditionally strong at private equity work. So obviously you've got like Kirkland, Latham. If you go to an open day at any of those firms, they'll always talk to you about their private equity work and potentially also their finance work. So if you do have a strong interest in private equity, it's probably actually better if you apply to US firms rather than UK firms, because whilst UK firms do it, they don't quite do it in the same capacity as US firms, and they'll generally just have like a corporate seat rather than a private equity specific seat.
Yeah, that's a good point. So US firms like tend to like focus on it a bit more, but you get like the odd firm that also sort of does private equity in the UK, but they tend to sort of be UK focused or maybe sort of on a small level pan-European sort of missions. But I know Freshfield's got a huge private equity practice as well, and that sort of does quite a lot of big stuff as well. But like you said, Danielle, it sort of separates its corporate group into different things. It's got a subset private equity group and different tiers. I don't particularly understand the structure completely. You have to ask someone there, but I think that's how it works. But it's an interesting concept to understand how law firms can add value to these private equity firms. So lawyers typically advise these firms throughout the life cycle of the fund, so 5 to 7 years, for example, if it's that long. And this will include financing a private equity firm's acquisitions when it's buying an asset or a company, advice on the actual acquisition or M&A process, restructuring or the insolvency process with that fund. Something that's happening at the moment is a lot of businesses are going under as a result of the pandemic crisis we're experiencing, and a lot of private equity firms are requiring sort of special situation advice, I think the term is, from lawyers, which is effectively advising how to restructure sort of debt, how to look into particular investments that were advantageous to that private equity firm. So that's one aspect of it as well. And then obviously the sale process as well, when they sell it on to either another private equity firm or another company, they'll need a lawyer to advise on that too. So effectively it is corporate law, but it's a particular niche of corporate law that is different in the way that a client will have a particularly long relationship with a law firm because they're advising them throughout this fund. So as opposed to a client going to different law firms for specific processes, they will come to your Kirkland & Ellis's, your Latham & Watkins, or your Vincent Elkins to advise them on one particular thing. And this relationship will sort of spiral over time because they've built up this strong client relationship through this 5 to 7 year period. And that's a great opportunity to build business for a law firm to generate more work in the future, as opposed to having to pitch to each individual client So that's one particular way private equity differs from corporate law more generally. I'm trying to think. So often when private equity firms are looking to purchase an asset such as a company as well, they'll do so partially from investor funds, but also partially from bank loans as well. And you may think, why are they doing this when, why are they getting a loan out when they have all the money? They've got, trillions of, the private equity sector has trillions of dollars of, I think it's called dry powder, which is effectively locked capital, which they could invest with. Why are they bothering to get bank loans out? Well, there are a few reasons for this. Firstly, in the current economic climate, it's a good idea to borrow because interest rates are so low and that debt is very cheap. As a result of sort of central bank setting those very low. And this also, by borrowing money, it frees up private equity firm investor capital to invest in other assets and sort of what's known as diversify their portfolio, which is effectively to mitigate value of their investment portfolio, or mitigate the risk of the value of their investment portfolio failing effectively. So if one particular investment doesn't work out, then you've got hundreds of others to fall back on. So this is a sort of way of mitigating risk. And so when private equity firms borrow money from a bank to make a transaction, they'll have to sort of negotiate what's known as a facility agreement that is both mutually favourable with both their interests. And this transaction is said to be leveraged, if you've heard that term before, which is why you might have heard the term thrown about at US firms as leverage buyout or leverage finance. This is sort of their bread and butter. This is what they like to do. And they just do this process again and again and again because it's so profitable. So yeah, I've talked enough. Danielle, it's your turn.
I think it's really clever what they do, but obviously you know a lot more about private equity than me, because obviously that's your sort of like main interest, I believe, like one of your main sort of interest going into a US firm, I suppose, always has to be private equity. But also private equity, obviously, because they purchase companies and things like that, you also get sort of the element of M&A. So if you are interested in both all of those things, so finance, as you've mentioned, with leveraged finance, M&A and private equity, I suppose private equity is the sort of all-encompassing area that you might want to consider. So corporate, the anatomy of an M&A deal. I think that M&A might actually be one of the most frequent sort of case study interviews where they give you a scenario. So they, all of the questions I've had that are scenario based have been based off an M&A deal. And I think that is because an M&A deal spans so much of the other practice areas. So, you might have real estate involved, you may have tax, you may have employment, you'll have financing of the M&A deal, you have competition issues. So there is so much that you can talk about with an M&A deal outside the remit of just the M&A group. So I would probably, I don't know about you, but I would really, really recommend sort of brushing up on your key sort of M&A features. So obviously knowing about the different types of agreement which are involved in a M&A deal. So obviously your main agreement will be a sale and purchase agreement, and that basically contains all of the key information. But you also may have a lockout agreement, which basically says, okay, we're in negotiation at the moment, like you can't then go and sell to somebody else. So it kind of like locks them into that negotiation, but at the same time it doesn't give them an obligation to buy. So it's just that sort of period. But I would recommend, obviously, on the slide we have lots of things like share versus asset purchase, so knowing the difference between those. I think when somebody first asked me when I was in second year what the difference between a share purchase and asset purchase is, or what it was, I didn't know, but I think that's so stupid, because it is literally what it says on the tin. Is share purchase is purchasing the company through equity, so they give you money in exchange for you giving some of your company away. Asset purchase is literally what it says on the tin, purchasing the assets of the company, but what they'll tend to do is they'll put that in like a separate they'll put them into like a shell company and then sell the shell company over. But yeah, there's so much to talk about. Where should we start?
Yeah, so I think sort of a good place to start would be sort of understanding sort of the structure that an M&A deal or transaction might follow. So sort of the anatomy, I suppose, which is firstly the pitch. So this will be a pitch for client work effectively, unless you have clients coming straight to the firm if it's particularly prestigious in that practice area. Or they have a long-standing client relationships, as I talked about with the private equity sector. Then you have sort of the internal and external checks that the law firm conducts, known as it's a form of due diligence, I suppose, to check that there's no conflict of interest with the client, that the client isn't doing anything illegal in effect. And then thirdly is the initial instruction. So this is sort of ascertaining the client's goals, setting out a time schedule for the execution of the transaction, and setting out a fee structure as well. Fourthly would be resourcing, so coordinating how the law firm practice areas will work together. As Danielle mentioned earlier, sort of a lot of the practice areas will overlap to an extent. So a corporate isn't just corporate, it'll incorporate intellectual property, it will incorporate aspects of finance, it will incorporate employment, things like these. So sort of coordinating how that is going to work is an element of sort of project planning which needs to take place beforehand. And sort of how these will work together and in the deal or transaction, how different offices, maybe if it's a multi-jurisdictional practice, will work together, or how different firms will work together collaboratively. For the case study we're about to do sort of a little bit later on, it's a huge transaction, and a lot of people misunderstand that, it's not just one law firm advising on this transaction. It can be sort of 5, 6, 7, loads of them if it's really big. So understanding that law firms work collaboratively together and there's not this sort of big rivalry with each other all the time is important. So sometimes they sort of outsource that work. Did you have anything to add to that?
Yeah, I think when I started looking into commercial firms, I didn't actually realise that you had to do client pitches. I'd never realised this until I went to an open day at Allen & Overy. And so obviously I just thought that the client would come to the firm and be like, oh, do this for us. But that's not the case at all. The client will go to the firm and say, oh, okay, so we're looking at doing this, like come and pitch for it. And they'll go to a few different firms who have that expertise and sort of flag it to them. And then you've got to sell yourself. It's literally like a selling game. So I think, another skill, if you can include it on your CV or your cover letter, anything that you've done sort of in selling something to somebody is always really good. And that's also a question that really commonly comes up in interview. How do we remain, how do we have a competitive advantage over our competitors? And that they're getting at that because they want you to be able to say why this firm is better than others and why they'll be able to perform work in a better or maybe a more efficient way than others. And so this is where the sort of client pitch stuff comes in. Just sort of looking at maybe the way that they structure their teams or the way that they bill or the softwares that they use can all be things that sort of set them apart from other firms and ultimately make a client choose them. I know that due diligence, again, is quite a commonly brought up thing in interviews on these sort of scenario-based questions. So just sort of having a knowledge of due diligence and also flagging up the things that you'd be looking for. So you maybe look at sort of the corporate governance structure, you look at their financial records, you'd look at maybe things like dividends and how much they pay out to other companies, to their shareholders, sorry. You'd look at human capital, so like employees and things like that. There's so much. You'd look at real estate, you'd look at existing contracts, you'd look at anything potentially contentious that's litigious at the moment or potentially later as well. And obviously, as Joe's put on the slides here, we mitigate those things through warranties, indemnities, those type of clauses, or alternatively, fundamentally, the way that you buy the company, because with a share purchase comes 100% taking of the liabilities. So you take all the liabilities of the company, although you do have warranties and indemnities in place there as well to protect yourself. But if you are potentially worried about some contracts or things like that, you could do an asset purchase and purchase everything except those sort of hazardous assets. So these are really, really clever ways that lawyers actually are able to protect their clients when they do purchase a company, because obviously you don't want to purchase a company and then find out that there was so much disputes that are going to arise later on, mis-selling claims, things like that. So I actually think that the way these contracts operate is really fascinating.
Yeah, absolutely. And it's such a common question in interviews. I found a commercial awareness question would be sort of in the scenario of a business acquiring another business. It would be that the question would be, for example, what should the acquiring business consider, what should it look into before it buys this other business? What does it need to know about this business before it buys it? And so I don't know, sort of, it's easy to think, okay, price, obviously, it's really good to sort of unpack these. So I've sort of done like it's a non-exhaustive list, but a long sort of helpful list of things you should consider. So for example, market price, the accuracy of that price, the corporate tax payable, which would be different in different jurisdictions, which is often why you see company headquarters in sort of low tax havens such as the BVI Islands, for example. Is the company public or private? Will it have to disclose key financial information publicly, or can it operate privately? What's the capital structure like? Does it already have a lot of debt obligations, restricted facility agreements with banks? Who else owns the shares? How much power do they have? Who has voting rights? Intellectual property is a big one as well. If a company's buying another, often you see sort of big tech companies buying sort of smaller tech companies, for example, because they want to effectively buy their intellectual property, which is things like patents, copyrights, etc. So they can incorporate them into their services and then sort of harvest the benefits. So making sure that those are included within the contract is important too. I suppose the jurisdiction is also important, so political stability, restrictive domestic laws, things like that. Key talent, you want to make sure that the directors who are doing so well for the target company are being brought on as well, and that they don't leave. You can control this with things like non-solicit clauses in the contracts, in the share purchase agreement. Litigation, for example, does it have existing or prospective litigation that could effectively devalue the value of the company? Are there any competition concerns, things like this? I could go on and on, but basically there's more things than just the price that you should consider, and showing a law firm that you've thought insightfully about each and every step relating to the practice areas that law firms deal with is a great way to show that you're commercially aware. But obviously this takes time and a real investment on your part, I suppose. But it does come after a while. I'd say after a few months maybe.
Absolutely. I also think that, taking it a step further and not just relating it back to the practice area, but relating it back to the work that firm has done. So, for example, have they worked on any similar acquisitions where these have been prohibited by the competition authorities? I think that's a really big one to think about, because obviously if they end up with a market share, I think it's above 25%, and they earn profit in the EU, then the Commission can prevent that. That's not even the UK authorities, that's the EU authorities, and they don't even need to have an office in the EU to potentially breach that. And there are so many different competition jurisdictions as well, which have different thresholds. And so this can be really, really problematic. It's just sort of flagging and saying, oh, I know you did this here and did this here, shows not only that you understand sort of the placement of these considerations within practice areas, but also shows that you have read about the firm's expertise and are further giving a reason why you'd like to work there, because you're saying, you did this, which was really, really good work and you did it really well, or you encountered problems here, but you've had this experience now, so you'd be able to respond effectively to that. I think that is linking it back to the firm is always a really key way to make yourself stand out.
Yeah, perfect. And also on building on that, sort of, it's a really good way to sort of incorporate into the why this firm question as well. So often law firms will ask you, why are you applying to us? Showing that you really understand what separates the firm from the rest is also a question of commercial awareness too. So sort of building on that, you'll be able to show that and sort of help yourself in that question too.
Yeah, absolutely. One final thing I did add was earn-out clauses, so that I know another question that you could get asked is, what happens if they sell the company and then the company does amazingly? Well, you could add an earn-out clause, and basically that's just a clause which says, if the company meets these certain targets, then they have to give some money to the seller. So that's another way that law firms can sort of use their contracts to really help their clients and make the deal sort of maximized as much value as possible.
Yeah, for sure. And it's sort of building on the retaining talent of the target company as well. So target company, by the way, is the company being acquired, and then obviously acquiring company is the company acquiring that company. So you want to make sure all the key talent not only stays, but is incentivized to work well, I suppose, and continue sort of creating value for that company in particular. So yeah, earn out clauses are a great way. There are other clauses. I think there's one called a ratchet clause, which is like similar to that. I don't really know what it means, but you know, these terms, like they do sort of, it's an example of you seeing strange words and be like, well, what the hell does that mean? But also you understand the sort of fundamentals of commercial awareness and all of this, then you're like, oh, okay, now it makes sense. And that's quite a good thing to include in the contract. But yeah, completely.
Absolutely. I think it's also a good thing if you sort of know the risks of an acquisition or a merger, because obviously there may be a cultural clash, because I find that businesses have such a distinct culture that sometimes a big problem that arises when there is a concentration is the fact that there's a cultural clash. So whilst it's not legal, understanding sort of all of the risks and all of the risks of an M&A deal is really key. And obviously most of the risks, apart from things like that, can be mitigated, as we've said, by the method of purchase or different types of clause. So yeah, have you got anything else to add?
Oh, I think we've covered that quite nicely.
I'd recommend, I mentioned it in the resources later, but if you're interested in knowing sort of a bit about like the different parties, different clauses, different agreements, Sherman and Sterling have a really good student guide on M&A, but it's flagged later, so don't worry about jotting that down just yet. Oh. Fundamentals of finance. So we've got this slide, and then the next slide will we sort of break down the different types of finance that you can get involved in. So obviously the two main types of finance are debt finance and equity finance. Leveraged finance is a type of debt finance, so it's like just finance using a lot of debt. And obviously there are some quite obvious advantages and disadvantages to both of these things. With debt finance, obviously you retain all ownership of your organisation because you're not selling shares, but the negatives is you have to pay it back plus interest, which, you know, as we've seen, as I mentioned before, can be quite high depending on who you're getting your loan from. And then obviously equity finance, positives, you don't have to repay the money, don't have any interest rates, so nothing's growing, there's no growing amount there. But negatives, as I say, you will lose part ownership of the organisation. Think of equity finance like Dragon's Den if you're struggling to grasp it, you know, how they go in, they sell, you know, 20% of their business for how much money they need.
Yeah, for sure. And I think with debt finance as well, it's important to sort of understand maybe the structure of it. So you'll have to repay the debt obviously by a certain date, and normally with a specific level of interest. So this interest will typically be to do with, at the moment, LIBOR or, you know, central bank set rates. So at the moment, as I've said, you know, it's cheap to get debt because interest rates are low. And for example, if you can't repay this debt by the contracted period, or you're said to have defaulted on your loan, which means that the creditor, the person who lent you the debt, can seize an asset with a security over it. So typically, you'll have sort of secured loans. For example, if you had a bank lending money to an acquiring company who was buying a target company, then perhaps the bank would have security over some of the assets of the target company, like particular machinery, for example. And if the acquiring company defaulted on the loan, couldn't pay the bank back within a set limit, then the bank could seize the value of this asset and sell it off. This is what it has the contractual power to do. In reality, this tends not to happen. They just tend to sort of renegotiate the agreement, so it's more sort of mutually economically beneficial for both parties. But it is worth understanding there is an element of risk, although typically it doesn't end up being that dire. But yeah, this is very common in sort of leverage buyouts and private equity too.
Yeah, absolutely. And also, another thing that you might be asked is what happens if the company chooses debt finance but isn't happy with the interest rate that they're being offered? And so if you really want to stand out, you could show a knowledge of derivatives. So there's a derivative agreement called a swap, which and the most common type of swap is an interest rate swap. So on loans, so for example, if you're offered if you're a sort of bit newer business and you want a loan for £1 million and you're offered either an interest rate of LIBOR +2 or 9%, and then you do a swap, and it works out very cleverly with somebody who also is generally taking out the same amount of money, or they do it really cleverly if it's not. And it actually enables you to get a better interest rate. You'll end up taking out the rate that you don't want. So if you want a fixed rate, you'll end up taking out the variable rates. And then it's just really clever what they do. And again, there is a video later on Money Week, which I flag in the resources, but also on my Instagram page, I've done like a handy guide to derivatives. And so I kind of explain what a swap is there a bit more eloquently, because it is quite confusing the way that they do it, but it is very clever. And so just flagging that and saying, you know, they could always go to a swap bank if they're not happy with their rate of interest to get a better rate, is again showing knowledge broadly without having to understand anything too complex.
And another form of debt finance, I suppose we should sort of briefly mention, is sort of bond issues and things like this. So, for example, a company might go to a bank for a facility agreement for a lot of money, but if they're trying to raise money sort of quickly, or they just need a little appendage on the side so you get something done in sort of a convenient manner, bond issues are very ideal for this. So they're on something called the debt capital markets, which are another form useful to be aware of. So companies effectively issue bonds, which are essentially promises to repay debt at an interest to individual bondholders on the debt capital markets. That could be institutional shareholders, that could be you or me. You can get sort of tiny portions of these. And it can be quicker and obviously less restrictive than bank loans, because you're not sort of restricted with a facility agreement with a bank that can effectively have the power to control your operations, tell you what you can and can't do with that money. And some of these bonds are very high risk because there might be a higher rate or chance of default on this bond, and these are called junk bonds or high yield bonds, so called because bondholders typically receive higher rates of interest that compensate for the risk that they take on. So if you've seen the word sort of bonds floating about and you just thought, well, what is that? That's what it is, and it's a good thing to be aware of. It tends to, especially in US firms, it tends not to take up the same level of interest as sort of big bank loans, but it's definitely there, and it's good to be aware of the process.
Absolutely. Okay, so the different types of finance work. So there are, this isn't even all of the different types of finance work, but these are like the key types of finance work. So project finance involves sort of the long-term financing of things. So this will be like infrastructure, maybe construction projects, energy and oil. Mining is quite a big one as well. And so it's a very, very long-term thing. So if you're looking for something where you've got like a finance agreement and you want you want to get it done like from beginning to end in like a month or two, then project finance definitely isn't for you, because it's going to be quite long. It can span over sort of 15 years, whereas acquisition finance is generally a lot quicker with the turnaround. But this is good if you, like me, like to see something tangible at the end of it. So especially if you're working on infrastructure and construction projects, because obviously at the end you can sort of point to it and go, you know, I helped finance that. But no, it'll be quite a lot of the time it's stuff like railroads or oil operations. It can even involve other forms of transportation. So that's quite an interesting one that I think is sort of different to the others, in the sense that it's a project, whereas the others tend to be deals. Have you got anything to add?
Yeah, so something I find quite interesting about project finance is a lot of it's taking place in sort of countries or jurisdictions where you wouldn't necessarily assume law firms would be involved with. Yeah. So a lot of sort of emerging economies, emerging markets in Africa at the moment. So you're seeing a lot of sort of foreign investment from China and the US and sort of European countries too, funding these projects, ultimately to drive a profit. But it means that, lawyers are getting hands-on with very sort of unfamiliar and dynamic, politically unstable and politically dynamic jurisdictions in which, they're posed with all sorts of different legal challenges they wouldn't otherwise be wouldn't be used to. So I think it definitely presents different challenges, and it's something I'm keen to get involved with as a trainee. But yeah, it's almost quite a niche because it has different challenges.
Yeah, absolutely. And what's really interesting as well is that because you're working in these emerging nations, you'll often find that you're, alongside working for companies, you're also working for local governments, which can be interesting if you're into any of that stuff. But it means that, you know, sort of the work that you are doing is really fostering change within emerging nations, and it's being sort of at the forefront of their development, which I personally think is quite exciting.
Yeah, for sure.
So obviously acquisition finance, we've mentioned before, we mentioned when we spoke about difference between debt finance, equity finance. You can also have leveraged buyout. There are other types of finance beyond that, obviously, but just sort of, I think, knowing just the basics of the different ways that a company can finance an acquisition and the pros and cons to those is generally the most law firms will expect of you, because they obviously don't expect you to know the absolute ins and outs and every single thing of acquisition finance. But yeah, just understanding how companies are acquired is a really helpful thing to know. Then you've got securitization, which is just where you take financial assets and then use them as securities. Often it'll be like pooled financial assets. Trading derivatives, so obviously we've already mentioned swaps. There's also options, futures and forwards. I've done some content on this on Instagram and also on LinkedIn if you don't have Instagram, which was just kind of breaks down the basics for you to help you understand it. Capital markets, as Joe already mentioned, equity capital markets and debt capital markets. And Islamic finance, which I personally think is really, really interesting because the transactions have to comply with Sharia principles. So that I think that's quite interesting as well. But all of these different types of finance work are so different, and I think that's what makes finance quite an interesting department. And I know that I'm personally quite excited for my finance seat, because I know that I'll get sort of drabs of different types of finance work.
Yeah, for sure. And there's something I maybe forgot to include on there. There's another one called asset finance, which is very niche, which is effectively the financing the purchase of expensive assets. Normally things like vehicles, planes, yachts, things like that. And then obviously taking security over these assets in terms of a bank's perspective would be quite difficult, because obviously you need to locate and deal with them, which, you know, it throws into the mix sort of the question of, well, which jurisdiction is it, and can I seize this asset if it's in a jurisdiction that I don't know how to deal with? So it sort of presents particularly niche challenges, and it's completely different altogether.
Yeah, I just think that things like that are so interesting, but also don't forget that the majority of business ventures involve needing to pay for something. So finance department will be involved on sort of all different types of business ventures, which makes it quite an interesting department to work in. But again, as we've mentioned, different law firms are structured in different ways. You know, at Slaughter maybe just have the finance department, and then everybody, when you're a trainee, kind of do a bit of different things. Whereas if you go to Freshfields, you'll have like a leveraged finance seat, which is just specifically on leveraged finance. So again, if you are interested in certain aspects of these, then factor that into why you want to apply to that firm, or if you want to sort of have a taster of all of them, then again, that's another why that firm. Have you got anything else to add?
No, it's good. I think you covered that well.
Dispute resolution. So yeah, we identified sort of the three. I think they're the three things that you should probably know about, because not all disputes go to court, and also other disputes. So a lot of contracts will contain something called an arbitration clause, which stipulates sort of the arbitration rules that they're going to follow, the seat of the arbitration, the language of the arbitration, the rules governing the arbitration, so and potentially also the arbitrators. And this is actually quite common in a lot of agreements which are cross-border, because obviously there are so many problems with cross-border deals, because then it's like, whose law do we follow, whose laws do we comply with? Do we comply with ours, or do we comply with yours? And obviously if you've got a civil law system and then a common law system, that can be quite problematic. So arbitration clauses are something that you might want to flag up, because it can sort of mitigate that risk of having the question of where what law the dispute's going to follow, because it stipulates the law, the seat, sort of everything, which clarifies a lot in advance. And then obviously with litigation, if there's no arbitration clause and it's not resolved in out of court settlement negotiation, then it will go to court. So litigation is just like court disputes. I think that a lot of people get confused with what it means. And obviously a key stage of that is discovery and disclosure, and that's a lot of what trainees do. So when you're doing e-discovery, you could have like potentially hundreds of thousands of documents that you need to go through and flag which ones could be potentially relevant to the dispute. So it's quite a lot, and that's often where they will get external paralegals in for like a 3-month contract, if you've seen any of those going on Indeed. So that's a really, really, really big stage in sort of the early stages of litigation.
But something I would add was sort of, I think international arbitration is particularly interesting, especially if you want to be a trainee solicitor in London, because London's a pretty central sort of global arbitration forum where everyone from the Middle East, from Africa, from all sorts of countries will come to get their disputes resolved. So you'll see sort of a lot of high profile work with high profile clients in London, and you really get great hands-on experience if that's what interests you. So yeah, definitely something to consider.
Yeah, and we also have the LCIA, which is like a type of arbitration board which will sort of deal with the arbitration. So lots of people use LCIA rules to govern their arbitration, which is based in London. So, but yeah, London is absolutely one of the most common seats for arbitration, which means that it's often held here, and it will follow English law or sometimes a different type of law. But yeah, no. Okay, key sectors. So so practice areas are what you work in. So you do M&A, you do finance, you do real estate, but sectors are what these practice areas work in. And it's really important to sort of understand these key differences. So energy and oil, as you've already mentioned, it can be it could be project finance work. It could also be corporate work, construction, infrastructure, real estate, finance, corporate. Like all of these practice areas really do get involved on these sectors. And personally, I would, as I've mentioned before, recommend basing your sort of news stories that you're following off of a key sector. These aren't all the sectors. There's lots of other ones. These are just ones that I personally felt were sort of the most important at the moment, but there are lots of others if you have a different niche interest, perhaps in retail or like aviation or transportation or something like that. So when I was doing my interview preparation, I did energy and oil with Saudi Aramco's IPO and the impacts of that on law firms' clients. I did HS2, which obviously relates to construction and infrastructure, and then I did LIBOR to SONIA, which again is financial services. So all of these three things were across the three big sectors.
Yeah, really, really good. And I think sort of being able to identify the key issues or threats to those sectors or opportunities, if it may be. Normally with law, it's threats. But if you can identify those and then be able to talk about them in an interview, it's really good as well. I often found actually, if you are being interviewed at a firm that specializes in a particular sector and you don't know who your interviewer is, so you can't research them and figure out, how to impress them, just figure out which their key sectors are. And then think of a deal that you've identified, learn it really well, and really understand their involvement in that particular sector, and then you can come at them with lots of good questions. So there's definitely a way to tailor your interviews on a sort of sector-based approach in terms of that.
Absolutely. And some lawyers may be working across all of these different sectors, others may be niche in a particular sector, which I think is a good reason why, even if you're really, really interested in energy and oil, for example, also have a look at what's going on in other sectors as well, and don't just because you can't hedge your bets on the lawyer in front of you who's interviewing you working in energy and oil. So what past events should you know about? I think the financial crisis, even though it was over 10 years ago now, is still a really big one. And LIBOR scandal is really big. Namely, that is really important to understand why we're moving from LIBOR to SONIA, which is an upcoming transition, which Joe's already mentioned, which is actually proving to be quite a task for a lot of finance departments, having to change a lot of their terms and their agreements or ensure that the fallback rate is SONIA. I think it's really important with the financial crisis to understand both the causes and the responses. So you might know this already. The housing bubble was formed due to subprime lending and CDOs. And basically, they were just lending mortgages out to people who were less than creditworthy, we'll put it that way, and who wouldn't be able to pay it back. And so they were lending, and then suddenly people couldn't start paying it back. So the whole market collapsed in America especially, and that actually had such a profound impact on the rest of the world. And there were also problems in the UK still with excessive risk taking, and obviously this all led to the depletion of confidence within the financial sector, which led to things like the run on the bank with Northern Rock, with people queuing up outside to take their money out. So obviously confidence is a huge thing that you should be aware of in the context of banking as a sector. It's really important that people have confidence, because banks never have the amount of money that you have in your account. They never have that in cash. So if everybody takes out their money, then there'd be people not able to take out their money because they don't have it all in cash. And that's actually where responses came in. So capital liquidity basically requires there was an increase in the buffer, which meant that banks would have to keep more money in their reserves than what they did before. Ring fencing legislation what this did was it separated the retail arm from the investment arm of banks, and this actually only came into force in 2018. It was really recent. Separating these two things meant that all of their risky sort of investment activities could just be separated, so the retail side was safe. So that, in accordance with the special resolution regime as well, meant that if the investment risky arm failed, then they could let that fail without a huge impact on people, because that retail side was still safe. So they are sort of the main responses. There was also some others, like the transition from tripartite to Twin Peaks. But yeah, I'd say that they were the three main ones that you should probably know about in the context of legal contexts. And they're probably the most effective ones as well.
Yeah, just to add to that, like, you've covered that really nicely. But for me, first learning about the financial crisis, it was a term that was floated around all the time, and I had no clue what it meant. And there's a great film, you might have heard of it, called The Big Short, which was like Oscar nominated. It was brilliant. And I'm not gonna lie, I've watched it about 4 times. The first 3 times, still had no idea what was going on. I just watched it because it was funny. But yeah, 4th time I was like, oh, it makes sense. So that's a good way of sort of incorporating commercial awareness, make it enjoyable, make it fun. Like Danielle touched upon sort of Dragon's Den earlier as well. That's a great way of understanding, what equity investors care about when they're investing into something, which is unbelievably good for developing your commercial awareness. That's also entertaining. Watch films about it, watch documentaries about financial crash, and then slowly, you'll develop that knowledge. You don't have to jump in the deep end, because that's terrifying. If you're anything like me, I just wasn't ready for that. So no, yeah, summed up pretty nicely there.
So the second one is the LIBOR scandal, and that sort of came about as well with the financial crisis. So LIBOR is the London interbank offered rate, and it's the rate that banks can borrow from each other at. And basically it's calculated by all of the banks, put in how much they can borrow, the rate that they can borrow at. And yeah, so what happened is all these banks colluded and manipulated the rate that they said that they could borrow at, so that their derivatives they get a nice payment from their derivative agreements. So Barclays was one of the banks that was heavily involved in the LIBOR scandal. And yeah, this was just such a big thing, and people ended up going to prison for it. And so that's actually triggered off the change from LIBOR changing to SONIA. But also straight after this, not long after this actually, the waterfall methodology was introduced to make LIBOR actually based off something, because before the banks could kind of be like, oh yeah, we're going to say this without any sort of economic backing to it. But the waterfall methodology introduces more economic financial thinking to make sure that they can borrow at what they say. And this led to obviously the transition to SONIA, which is going to happen in 2021, but we'll be discussing that on the next slide.
I could talk about the US-China trade war for a little bit. So there's a lot to delve into here. On a surface level, the war, if you will, is sort of largely animated by policies of protectionism, which are effectively imposing tariffs to protect industries that can't compete with the international markets. So, for example, if you impose tariffs on foreign goods, then you have to pay an additional tax on these foreign goods, making them more expensive, making them less attractive to the average consumer, meaning that domestic goods of the same caliber or the same industry will be more attractive to you, and then you'll buy them more, and then the foreign goods less, which is obviously good for your own domestic market, but not good for the foreign producers. So this is why it's called protectionism, it's protecting your own sort of domestic sort of setting. So it's so first let's look at the sort of direct impact of the tariffs on companies that import Chinese goods, for example. So these companies now have to pay a tax. So they have two choices. They can either absorb the cost or pass the cost on to consumers. So if they absorb the cost, their profits and their bottom line takes a dip, which will cause them to cut jobs and have to restructure. And if they pass on the cost to consumers, they're damaging their reputation or seeing reduced sales, especially in sort of very cost-sensitive markets, such as many of the markets that we're in at the moment. So companies that export to China will also be impacted because of China's retaliatory tariffs. This is where the war element comes in, sort of it's been to and fro, a bit like an arms race, if you will, but with tax, so nowhere near as exciting. So these tariffs mean that like US goods will be more expensive to Chinese consumers. So if exports fall, companies lose money, which can lead to fewer jobs and sort of depressed wages and things like this. So really, it's not beneficial for either party. But what does this mean for law firms? Well, law firms will have seen an increase in sort of counter-cyclical practice, which is sort of cyclical practice is practice when the economy is booming. So M&A will be an all-time high, financing, things like this. Counter-cyclical practice is when the economy is dipping. So things like restructuring, insolvency procedures, things like this. And then obviously sort of lawyers are having to factor in new terms into contracts, like including the US-China trade war. So this will happen if the US-China trade war affects this in this way. Something really interesting about contracts is that you can contract for literally more or less anything. So I've read about sort of a Jeremy Corbyn clause in a contract recently, which was if Jeremy Corbyn gets into government, then this will or won't go ahead, because obviously the policies that he would implement would be so radically different. I don't know radically, but radically different to the Conservative government policies in certain areas. So I think sort of taking that into account is important too. But that's sort of a brief overview of US-China trade war.
So what future events should you know about? So obviously we haven't yet, but cybersecurity, understand why it's an issue. So I think with cybersecurity, what makes it particularly interesting is that there are always technology gaps. And so you're always going to have cybersecurity at the forefront of sort of any business operation in order to mitigate any risks. And, as long as you have technology gaps, you can have potential cyber attacks. And you can look at the cyber attack on DLA Piper to show that these don't just impact clients, but also law firms, because law firms are businesses. And the importance of this is crazy, because if you think about how much confidential information law firms and other businesses store, and how attackers can actually utilize this against the firm or the business, and say, give us this amount of money or we'll release all of this confidential information, it's actually quite scary. So they are huge, and they don't just affect the client, but also the law firm. And obviously we have GDPR and e-privacy, although I don't know if that's going to apply. I don't know if that's going to apply to us now that we've Brexited, which is basically like the electronic version of GDPR. But obviously we still use GDPR, don't we, the standards? So that was something that was brought in to sort of make sure that everybody's cybersecurity was tip top to sort of prevent against these breaches.
Yeah, and it's something that's quite interesting about cybersecurity is, so it also affects law firms, which, the DLA Piper 2017 case is a big example. That was a big no-no. But also it also affects clients as well in every sector and every industry. So it sort of, affects everyone. It's pretty scary. And there have been lots of regulations which impose quite stringent requirements on law firms to mitigate these responses. So not only are law firms at risk of these threats, or clients at risk of these threats, but they're also at risk of massive penalties if they don't abide with regulations that will mitigate the risk of these threats happening. So it's kind of like a double-edged sword, if you will. So making sure that you're prepared for both of those is important to understand as an aspiring lawyer, I suppose.
Absolutely. I think that if you want one of your commercial awareness topics to sort of be cross-sector, as you say, this is a good one, because it literally, there's nobody that it doesn't affect. It doesn't discriminate. any business that contains any confidential information is at risk of a cyber attack. And obviously most businesses take, I think every business actually, every single business needs to earn money, so they take payments and say that's even more potentially problematic confidential information that could be taken and extorted. And obviously there's like password sniffing. It's actually quite interesting if you get down to it, because there's always developments and there's always things that happen. So if you want like a news story platform where there's constant developments and it's literally never going to end, is always a good one to choose. So the next one, which I've already spoken about briefly, is the transition from LIBOR to SONIA. So SONIA is the Sterling Overnight Index Average. It replaces LIBOR, and so the Bank of England are no longer publishing it from 2021. I think it's the end of 2021 though. And so obviously law firms have currently got the huge task of either changing LIBOR wording so that if any issues arise in the future, they can find it quite easily. But also contracts that are quite clever may already have SONIA as the fallback rate. So that's in the event of no LIBOR, we'd use SONIA. So a lot of law firms have already sort of dealt with it. I mean, a lot of them have already changed a lot of their contracts, but it's such a big thing because obviously $350 trillion worth of derivatives are underpinned by LIBOR, which is a lot of derivatives. But yeah, one of the key differences between SONIA and LIBOR is that LIBOR has lots of different maturities, whereas SONIA is literally just an overnight index average, which I think makes it makes it safer because it's based on yesterday's. So it's got advantages, but also LIBOR rate and SONIA rate are not identical, and so there are potential litigation risks there. But I think that this is the kind of question that you need to be asking law firms about. So when I went to an open day at Allen & Overy, I said, what are you doing to mitigate against these risks? And so they've got like this litigation risk exercise thing that they're doing with one of their specialist groups. But all different law firms are doing different things to address this. And obviously because it's such a big thing, it's always really good to go and ask them about this, because then you can mention it. And when you're giving your commercial awareness speech to them at interview, you can say, well, I've actually spoken to your lawyers and I know that this is how you're dealing with it. And it's the same with cybersecurity as well. If the firm has any particular processes that they follow, go and ask them about it. If you don't know about it, if you can't find it online, go and ask them about it at an open day and then link it back to the firm, and that's going to be super impressive. Have you got anything to add?
No, I think you've covered that really nicely. It's just such a big thing. It's going to affect so many firms and the way they deal with their finance and operations like that. So definitely worth knowing about. You may not have to have sort of a deep expertise of it all, but just showing an interest in it and sort of understanding the fundamental concepts is definitely a good thing to do.
Absolutely.
Shall I talk about tech and AI for a little bit? So yes, so I think legal tech and legal artificial intelligence is also something that's quite interesting to talk about because it's both a threat and an opportunity to the legal profession. So it might be deemed a threat because technologies are threatening to sort of usurp or take over legal roles in the profession, such as sort of journeymen, what we call journeymen lawyer jobs. So things like drafting wills or drafting basic contracts or reviewing documents are now all doable by artificial intelligence. Not only more accurately, not only more quickly, but much more efficiently. So any law firm that outsources these duties, if you will, to an AI firm, such as, Luminance as an example, or Kira, I know is used by the Magic Circle, then by capitalizing on these efficiency gains, they can therefore undercut the market prices of their competitors, which will completely sort of starve their competitors of any sort of business that they were previously having. So they are going to suffer a lot as a result of that. However, this is only the case with what we call journeyman lawyer jobs. So things that are relatively easy to replicate, like drafting wills, or things that can sort of just be substituted. However, in the there are also a speculation about what can happen in the future, and as artificial intelligence improves, how much is it going to encroach on the legal profession? So it's definitely worth keeping an eye on in terms of sort of legal tech in the news, and it's quite interesting once you realise how big an issue it is. But also it's an opportunity. So, for example, for prestigious firms with very established reputations, that are adaptable or have a particularly niche practice that can't be encroached at all by artificial intelligence. Like I said, they can leverage this artificial intelligence to increase the efficiency of their processes. So, for example, they can complete due diligence much quicker. They can do document review much quicker, much more efficiently. The Magic Circle are jumping on these. US firms are starting to jump on these as well. And everyone's realizing that it's the way forward. And every law firm that isn't jumping on these is slowly being left behind. So, yeah, it's definitely something to consider for the future. And it's definitely understanding the benefits and appreciating the benefits and be willing to sort of harness them as a lawyer in the future will be very important. So I think it's important, especially in an interview in terms of commercial awareness, to evidence your interest in this. I would definitely help stand you out and will do some favors.
Also, yeah, absolutely. Also, the fact that a lot of law firms are jumping on board is really starting to foster the need for innovation. So if everybody's sort of hopping on board with these AI technologies and things like that, it means everybody's going to be able to deliver this efficient service. And that's why law firms are suddenly so like, we need innovative lawyers. And they have like also, I know Clifford Chance also has like a tech kind of training contract as well, and that's why tech is so important, because they want creative people to come up with the next best ideas as well and work with these AI companies, and they want to hire better AI companies so that they can have the new thing on the market which is going to undercut other competitors. But yeah, no, I everything that you said there, I absolutely agree with. Do you want to start this one?
Yeah, so I mean, how can firms add value? So it's important to, I think it's sort of the final step is to link commercial events to how a firm can add value for that particular industry. So for example, in any economic recession, whether it be 2008, whether it be the one that we're either falling into or coming out of now, who knows? There's, as I said, there's always a spike in counter-cyclical work. So this will include an increase in sort of litigation, restructuring, insolvency, special situation fund management work, which will be beneficial for law firms who have those practices and detrimental to those who don't, who rely on M&A and things like this. So something I appreciated in my application strategy, when they asked, oh, what kind of firms you're applying to, I said, well, I'm applying to firms that can appreciate, and have a strong counter-cyclical practice as well. So they're also specialized in special situations or restructuring, because they are, they'll keep a nice steady line throughout sort of any sort of environment, economic environment that sort of influences them. Whereas firms overly dependent on M&A, for example, will experience big dips. And I think going into the future, you really don't know what's going to happen. So I think choosing a firm that is versatile and adaptable to that in its approach to it with its practice areas is definitely important. What else? So there's also an increase in foreign investment in emerging markets. So, for example, from America and also from China, and this has led to sort of an increase in construction and project finance work. So you'll see a lot of increase in the work here. So maybe going to a firm which specialises in those would be good for the future. How can law firms leverage legal AI to outcompete rivals and increase margins? We've talked about this, touched on this briefly already. So I think there's all sorts of ways you can link, okay, what's happening in the news, what are clients doing, and how are law firms adding value as a result of that. And sort of getting into the habit of sort of cycling this round and round is an excellent way of demonstrating commercial awareness, which is something so many people often struggle with.
Absolutely, I completely agree. I think it is mainly in technology, but it could also be in the way that they structure their teams, which I briefly mentioned before. So if they structure their teams in a way that they can do more work more efficiently, I know that different firms have different processes and things like that, then this is something that you could include in an interview. So for example, obviously if you know about Slaughter & May, you'll probably know about their multi-specialist approach. So that's a way that they can add value, because their lawyers have sort of this understanding of like the broader elements of the transaction. So but this is, every law firm has a different way of doing it which they think adds value, and so it's just about pinpointing that and saying, you do the specific thing in addition to AI, which lots of other firms are using. This is what you do specifically, and this is how you structure your team to sort of be the most efficient and cost effective, but also deliver the best service and get quite a lot of money out of the client. So but yeah, also I think it'd be really good to keep updated on the types of AI that they are using. So if there is a new product coming out that they're testing, you can always mention that in an interview and say, you're testing this, if this works in the future, then this could potentially really, really help you deliver the most efficient, best service to the client and pass on those benefits to them, which are going to make them want to come back. So yeah, I think just having a look at what they're doing, as well as sort of wider things like AI, are really good to show how they can add value. So this is the sort of application process side of things. So obviously you've got case studies, and we'll speak about those a bit more in depth in a second. And then there's also the, typical describe a news story question that I think everybody gets in some form in their interview. It might just be worded in a different way or like targeted towards a certain sector. But do you want to have a go first?
Yeah, so case studies. So when you approach these, I mean, they can take firstly different forms. So I know Stalker may have sort of a written case study. I think Latham had a written case study as well. They'll often be very time pressured. So first you need to structure your answer, structure your time very efficiently. Otherwise, you're going to make all sorts of spelling mistakes, grammatical errors, and just not provide the standard work that you're capable of. I think also, there's also the commercial awareness case study given to you in an article form where you'll have to read about it for 10 minutes. Then you're asked to discuss what interests you. And I always struggled with that. I always thought, okay, why do you want to know what interests me? Surely, how do I answer this? Effectively, what we're asking you to do is identify the threats and opportunities, and following sort of a SWOT method as listed there, and a sort of a PESTLE method too will help you sort of adhere to a good sort of structure that will help you answer the aspects of the questions that they're inherently asking. And yeah, so describe a news story one's a very common one, which comes up in application questions too. There's a certain structure you can follow to this too, which helps. But yeah, Daniel, how did you find the whole sort of case study process?
So SWOT's case study is a bit different to others because you're advising in a business capacity. So you really do have to think about SWOT. In fact, they literally tell you to structure your answer in a way that's really similar to SWOT. So I went in advance knowing SWOT, PESTLE, and Porter's 5 forces, because I knew that I was going to have to make a business decision. And to make a business decision, you need to evaluate the business the impacts on the business. So I structured it in a SWOT format. So that was my structure. So I discussed the strengths first, the weaknesses and the opportunities, and then the threats of each of the options, whilst also considering the political, economic, sociological, technical, legal and environmental factors within those strengths, weaknesses, opportunities and threats. So I used SWOT as the structure and then incorporated the other things in there. But I also think Porter's 5 forces are really, really good if you are asked to do something in a business capacity. So you've got to think about competitive rivalry, how much power does the supplier have, how much power does the buyer have, what is the threat of substitution, and what is the threat of a new entity coming into the market. So that these are really good things to just even flag, because you might not have all of the information in front of you about these things, you probably won't, but supplier power was one of the big reasons why I chose the option that I did, because it involved working with a supplier. And so like just knowing these things is going to make you go into that written or verbal case study understanding the key factors that businesses themselves will have to contemplate when they are making these decisions. And then obviously with describe a news story, I'd still approach it with like risks. So like SWOT, I'd still think SWOT when I was reading it, because I think that's just a really good way so that you don't miss anything. Because I feel like if you don't go in with like a preset in your head structure of how to assess and identify risks and opportunities, then you can miss things. And then obviously I said choose something you are interested in but also impacts the firm or their clients. So I did, as I said, LIBOR to SONIA, because like I literally find it so fascinating, and it impacts banking clients and the finance department of a firm. Sally Aramco's IPO affects oil and energy clients, which affects lots of different practice areas in the firm, and HS2 infrastructure project. And actually what was really interesting was with HS2, both Slaughters and Herbert Smith Freehills, which were like my 2 interview periods in November, both worked on HS2 in a different capacity. So, and obviously if I was going to go to a law firm that didn't work on HS2, then I probably wouldn't have mentioned it. But yeah, so you're interested in, because they can tell if you're not interested in it, because they're going to ask you a question about it. And if you don't know a simple follow-up question, then that shows that you're not really interested in it. Because when I was reading about these things, I didn't mind it, so I was reading quite a lot about them because I found it quite interesting, and so I was able to talk about it with passion. And they asked me, would you invest in Saudi Aramco? And I said, I gave my answer with my justifications, which I'd been thinking in my head but never actually thought they'd ask me. But because I've been reading so much about it, I was able to give like a really educated answer.
Completely. And what I found as well, going into an interview specifically or especially, was I was always a bit worried about, sure, I'm going to run dry, run out of things to talk about, and I was a little bit scared that I was just kind of be sort of I'd mind blank almost, and I wouldn't say enough, for example, to impress or fully demonstrate the commercial knowledge that I had. But I found at least following some sort of SWOT structure really helps you draw links between different concepts. You can probably tell from hearing me and Danielle speak. We can just talk on and on and on because we can make links between things, and it just becomes very easy and almost natural to demonstrate a commercial awareness once you know how to make these links, and there's much less pressure on being able to sort of identify each specific thing. So I think definitely following a structure for that is very important, and it will help sort of convey a bit more of a natural ease when you're discussing commercial awareness. But obviously that will it comes with time.
What to ask your interviewers. So this is like the least spoken about thing I think I've ever seen in all of the workshops that I had a look at when I was doing my interview. But when they say to you, okay, that's it from us, have you got anything that you'd like to ask us? That is worth just as much as a question from them. They asking them, what's your culture like? Okay, if you link it back to a specific thing that, you do this, so does this make your culture really collaborative? That's okay, because you're linking it back to the firm. But just asking a really generic question like that, they're not going to be very impressed. And they're all going to give you the same answer, which you're probably not going to care about, because every single law firm says that they've got a good culture. Like, I don't know one law firm that has said, actually, our culture is quite toxic. Because why would they? Because they want to recruit you. What might be a good culture to one person might be a bad culture to another. So it's also hugely subjective. So I would say, for one of your questions, not all of them, or maybe two of your questions, feed your knowledge of commercial topics into your questions. So show, if you don't feel like you've demonstrated enough commercial awareness in the answers that you've given, this is a good place to redeem yourself. So obviously one of the big things that I had a finance partner in front of me, and so I knew that he would be working on the transition to SONIA. So I said, how are you planning to mitigate the risk to clients impacted by the SONIA transition? I'd actually been fortunate because I was on the Aspire scheme with aspiring solicitors. So I had loads of exposure to Barclays and Merrill Lynch, who were both Sorters clients in some capacity. So I was able to say, I've had a chat with your clients, I know what they're doing, but what are you doing from an external perspective, which is really going to help make this transition a lot easier and mitigate any impacts. And so that's showing I've tailored it to that lawyer, so he knows that I know that he's going to be able to understand that, and he knows what's going on and he's working on it. But also it's feeding in that I know about liable to SONIA. Obviously with real estate, there's been a reduction in work because of coronavirus, with obviously lockdown, meaning we all have to self-isolate. I think that's getting better now, so that might not be as relevant, but you could always ask about what were the impacts that you had, and is it getting better? What I know that you've done this in real estate, or any recent projects that they've done, and you can ask if there were any issues with that because of the pandemic. And then obviously with a disputes lawyer, how is the team planning to deal with the backlog of cases that the pandemic has caused? Because there is a backlog and it is large, because although there have been some Zoom court sessions, that is not at full capacity, that they have not been running every single court session. But that is how to feed, in my opinion, commercial awareness into your questions.
Yeah, it's such an important thing. I'm amazed that more people don't realize how important it is. I would say for all of my interviews that I passed, I probably spent maybe 40 to 50% of the interview with me leading the discussion. So I was asking them questions for most of the time. And I think actually maybe it's more important than the actual questions they ask you, because it shows firstly that you're comfortable speaking to them. It's a great opportunity to build rapport with the partners. It's so important to develop an authentic interest and an authentic commercial awareness. But as Danielle was very rightly saying, you need to, if you do ask any questions, firstly, make sure you absolutely know what those questions are, what relevance those questions have to the firm. You thoroughly research them, especially if it's transaction, but also be able to answer questions that they may come back at you with. So really forming it into sort of a dialogue as opposed to a one-on-one interrogation is very important, and I'd probably say is one of the most important things that work for me. And it's amazing how little people know about it. So if you get to the interview stage, this is a big one to think about. Try and go into it with maybe 5 or 6 tailored questions that you can follow up on as well. But yeah, huge point.
Absolutely agree. Follow-up questions are, I think, the most important thing to do, because if I say, oh, like, what are you doing with this big issue is happening, how are you responding to it? And then they go, oh, we're doing this, and I go, okay, thanks. Yeah. It doesn't look like I'm actually interested, and it kind of looks like you just said it to say it rather than say it because you're interested. So I'd fully always recommend asking at least 1 or 2 follow-up questions to that question, because then you're going to, as you say, get into that dialogue, and that dialogue is so important, I think, in building that rapport up with the interviewer. And also, you're comfortable, you're confident. It's really showing confidence, and you're going to have to ask the client questions. So if you can ask the lawyer question, that's a pretty good start. So yeah, 100% do not just go, okay, thanks, after they've given you an answer. Always ask follow-up questions, because it just shows a genuine interest. Oh, these are the resources, and then it's the case study. So for everybody who's been asking about the resources, we've got some more on the next slide as well. But for researching practice areas, I really found Sherman & Sterling, A Student's Guide to, which is what I mentioned earlier, really, really, really beneficial. So they have one for M&A, project finance and development, finance, and antitrust and competition. So these kind of break down the key elements of a deal, the main parties, the main contracts, the main clauses, the keywords, the jargon, and sort of how they got involved. And some of them even have a video talking about how they got involved as well. So that's a really good place to start.
Yeah, I really liked Chamber Student practice areas. I think that helped me out so much. So basically, if you haven't used the Chamber Student website already, it's an unbelievable sort of
so good
resources where you can research firms to a certain level of depth, although I'd say you need to go further with regard to really demonstrating that extra interest. It's certainly a great starting point. And they have a practice areas section where you can learn about sort of an overview of each practice area, the issues facing that practice area or the sector which that practice area deals, what lawyers do, things like that. And it's a very honest and very comprehensive insight. And I'd say they have about, they have quite like almost 20, but I'd say maybe dedicating your time to reading and understanding, making notes on one of those a day for about, 2 to 3 weeks would be a really good start.
Absolutely. And also things like Investopedia are really good for understanding the elements of practice areas, especially from a finance perspective. So I know they have stuff about trading on there, which is obviously an element of finance. They have stuff about mergers and acquisitions on there as well. So I think Google's a very, very helpful tool. I think the whole Corporate Law Academy also have some content on this, which is free. But yeah, literally, if you just Google like law practice area corporate finance, it should come up, and you can just start compiling. What I did is I compiled like Word documents and stuff with all the collated information, so I'd have it sort of on one page, and I found that really helped me. But yeah, I also used the Chamber Student practice areas, and I thought that was really helpful as well. For researching the anatomy of a deal, again, Sherman & Sterling's a guide to, but also Alan and Overy's The Anatomy of a Deal video is so good. I thought it was really engaging. I really enjoyed it. Did you watch it as well?
I don't think I have actually, but I've heard a lot of good things about it. So yeah, maybe I should check it out.
It's just, when you're applying and you want to know a bit more about like just a deal, you want to just understand sort of the basics. I mean, you already know like more than the basics anyway, so but it's really good for just sort of grasping these key concepts at first. I found it really, really useful.
Yeah, absolutely. And I think it's sort of peace of mind as well, because you realize, well, certainly from so I read the Jake Sugar Commercial Law Handbook, which was, it's pretty much revolutionized my application success, so I definitely recommend it. But it had like an anatomy of an acquisition, so I've listed those in the previous slide. And it's peace of mind, because okay, this is the first step they take, this is the last step they take. These are all the steps in between, that I now know that there's nothing that I've missed out. And you can approach interviews and applications with a lot more confidence through sort of understanding it in its entirety.
And then you've also put the Freshfields case studies, which is what our case study is based off. Well, that's what it is. We've literally just brought over the Freshfields on because it's like really, really helpful. And it kind of covers a lot of different areas. So our next resources is for understanding finance. The Money Machine, How the City Works by Philip Coggan is really, really, really good if you respond by reading. I found it quite digestible reading, not all reading I get, but I did get this one. Money Week is a YouTube channel and it's amazing. It literally revolutionized my perspective of finance, and it explains like things like derivative, all of the futures forwards, if you respond well to a video and a whiteboard. It's literally like an A-level class. It's so good. And he just like does diagrams, and it's literally the best thing ever. So I fully recommend having a look at him. Also attending open days and attending practice area workshops are, I think, really, really good. So I did a few at like Reed Smith, Alan Overy, which had like tasks where we'd learn about like practice areas and like what they do, and we'd work in teams and stuff like that. So I found that really, really helpful.
Yeah, I think open days are so important. I think often people will utilize open days as a opportunity to say, oh, look, I went to your open day, therefore I'm interested in your firm. But I think they have so much more value than that. So you don't even have to apply to the firm that you went to an open day for. You know, you might not even like the firm as a result of that. So I did open days at Clifford Chance, Freshfields, and K&E, which I did apply to. And I still have the resources that they gave me. I think so. There was like a private equity workshop, a debt finance workshop, a general sort of corporate M&A workshop, and I still have the notes, and I refer to them in every application I do. In terms of, you know, how did I generate my interest in this particular area or commercial law more generally, and it's been so useful, and I keep referring back to them for every interview, just to check that I'm along the right lines and sort of calibrate my interest in that firm. So yeah, no, so important.
And then keeping up to date, the Economist and FT, as I said, I think the Economist is better to start with, and then once you get a bit more confident, then go to the FT. But I would advise getting to like FT level by interviews, because you might get an article on the FT in your interview. Finimize is really good. They like send you updates in like, I think it's like less than 3 minutes. So I was reading those. And then what I would do is, if any of the stories really stood out to me, I'd then go and read a bit more about them. The business update is something on LinkedIn. I think it's quite new and it's really good. I follow it still, and they have like it's like infographic visual stuff, and it will tell you about like a deal. It will tell you what firms are involved, like the key interview essentials and takeaways and things like that. So that's a really good thing just to like on LinkedIn, and then it just comes on your feed. Bright Network Commercial Awareness newsletter I was subscribed to when I was doing my applications. I found that really helpful. And BBC Business I found helpful as